Yeah, see, stand right there. Let me see, look.
Jefferson County Court Law number 2 is back in session. The court is in session with the bond forfeiture docket. State, are you ready?
We are, Your Honor.
Okay, you may proceed.
Your Honor, I believe that there are some of the bondsmen here that have some issues with some of these cases, and I don't know who wants to go first. All right.
Yes. What case is that?
Good afternoon, Judge.
Good afternoon. What cases we have that's on the docket that you have issues with?
Oh, I don't know. They haven't told me yet, Your Honor.
Brian Scott.
Scott.
What's the NICE number?
Okay, Scott is right here. Okay.
Kevin.
I've got the defendants in alphabetical order.
Oh, you got them in alphabetical order? Oh,
Yeah.
Scott down here.
23CCCV 0207.
Okay.
That's one of them.
King.
King is Elax King.
Yes, Judge.
Clause number 23CCCV 0195.
Pascal.
Pascal is clause number 23CCCV 0265.
Hunter.
Hunter as James Hunter,
Yes, Judge.
clause number 23CCCV 0354.
John Singletary.
And John Singletary, clause number 23CCCV 0223. That's 1, 2, 3, 4, 5. Okay. Which one you want to proceed on first? You want to start
Happy
in
to go in the
alphabetical
same
order?
I just gave to the court, Judge, if that's okay.
Oh, okay. Just Scott. So Scott is first?
Yes, Judge.
Okay. You may proceed.
Thanks, Judge. My position on this is that this case is controlled by section 2216C Code of Criminal Procedure.
2216. See, okay.
That section and that statute, Judge, lay out the grounds for what happens when a citizen is rebonded. Mr. Scott was rebonded on December the 11th of 2023.
Did you say December 11th of 2020? Oh, he's rebonded on December 11th, 2023.
Yes.
You said 2023?
Okay.
Okay. So for the sort of interest accrues on the bond amount from the date of forfeiture in the same manner and at the same rate as provided for accrual of prejudgment interest.
Yeah, they're already up there. Yeah. Yeah. There's actually 24 requirements. Right, yeah, I mean, it's 2216.
Okay, now, those numbers need to. So y'all have a problem with the interest? That, you saying the C says, 22.16. C says for purposes of this article, interest accrues on the bond amount from the date of forfeiture in the same manner and at the same rate as provided for the accrual of prejudgment interest in civil cases.
Huh? On this one, Scott, we show interest to being $60.41.
Okay, so it's not full pot because they were over the days. So it's
Right.
changed since we got that letter last week. Is that
Right.
correct?
Right,
Okay, so we went
Right.
back to the old way?
right,
Okay,
right.
all right.
That's what that letter said.
Okay, well, I didn't get it till late last week and we
Oh.
already done our homework before then.
I apologize.
Okay.
All right. Does that take care of a number of these or
Yeah, y'all might need to get together and
That takes care of that one.
that one?
For sure.
Which other ones does it?
He likes King also.
King? Okay. I'll mark those out.
Now, you have that one as full pot.
Full pop. When was he rearrested?
Case was dismissed.
When was the case dismissed?
September 26th of 2023.
9/26. But when did you notify us that it had been dismissed?
Y'all were self-notified on.
We
September.
don't go through and check the files. If the bondsman wants to show arrest or dismissal, then it's on the bondsman to come forward and tell us. They're saying 9/26/23.
I notified you at the hearing that we got notification.
Yeah, well, 22/16 says you file a motion. So,
We'll go ahead and-
let's see. After provision written motion. Yeah.
Your Honor, do you show the case? I mean, we don't have the computer up. Do you? show
Oh,
what the
hold-
case was?
Hold on a minute.
Oh, we got the dismissal here.
Oh, you do?
Yeah. September 26/23. Yeah, Your Honor, we'll recalculate that judgment with interest back to the date of dismissal.
Okay.
So let me clarify what the statement you just made before that. Are we you gonna want written motions from now on 22/16?
Well, I mean, if you're coming in here arguing that under 22/16, you're entitled to some reduction for remediature, according to 22/16, the first thing it says, based on a motion, then that way we know what we're doing rather than coming down here wasting the court's time to look at a case that we're in agreement that that's court cost plus interest through the date of rearrest or dismissal, I guess, on this case.
Okay. Okay, what's the next case?
Cody Pascal, Judge.
Okay. Okay, that's 23 CCCP 0265.
What is that?
He was in the Hardin County Jail at the time of the forfeiture.
Okay. You got the records for that? Okay. What was the date of forfeiture? 6/14. Release date.
Let's see, it's from
Where did he?
He's in prison.
Oh, they sent him to the pen. Oh,
6/7/23 is your date of forfeiture. He was,
for Pascal? I'm showing 6/14.
I'm starting 6/14, that's the Nisi file date,
That's the Nisi
6/14.
That's the Nisi date, but the
Right.
forfeiture date was probably a week before that.
Could you look up? Okay. Hold on a minute.
Either way,
I'm trying to
He was
think.
in custody.
Yeah.
I mean, that
That's,
goes,
yeah.
that goes three,
five
two.
days.
Wonder why,
Okay.
I mean, it's.
Are you able to get?
Three
I'm
months
in there.
before.
But look up a guy by the name of Cody. It's Cody Pascal
All right, I mean,
Paskel.
I'm trying to think of.
Criminal, if you need the criminal number, I had that.
Judge, this guy was in jail 3 months before, so I mean, the 7 days really doesn't.
Yeah,
Okay, it's saying that this gentleman was in jail. When was the bond forfeiture?
It's still coming up.
Oh.
I'm sorry.
but anyway, yeah, because he was in jail for quite some time. He was in there March of 23.
You need a case number?
At M.
M333432.
Six 14.
Oh, it says the same day of the Nisi, 614, yeah.
Okay, again, Your Honor, I've got to look at, I don't have, may I borrow the court's code of criminal procedure real quick? Right, yeah, let me borrow it. Well, I guess I can pull it. No, I didn't even bring my phone.
What you,
Section.
22, 15, 2213, I'm sorry, 2213. Trying to see whether that's complete exoneration if they're in custody on the date of forfeiture, or whether
2213.
it's court cost plus
It is.
2213.
22. Causes for, here you go.
Yes, Your Honor.
And it's,
All right. Thank you. Sickness. Incarceration principle. Yeah, I think that still falls under subsection 2213(5), which would be court costs. We'll do court costs.
2213.5.
Does that sound right? Court
The
costs.
incarceration of principal for any jurisdiction.
there's no interest because he was already in custody.
At the time of not later than 180 days.
Why
after
are
the
they,
date.
tell me where to look that you're citing that they're responsible for the
2213.
court costs and not the.
2213 A5.
Will exonerate.
At the time
Sure.
of or not later than the 180th day of the date of the principal.
Incarceration of principal in any jurisdiction in the United States in the case of a misdemeanor at the time of or not later than 180th day after the date of the principal's failure to appear in court. Let me see, death of sickness, principal, some. It doesn't fall under 2213 A3, like a some uncontrollable circumstance which prevents his appearance at court.
Well,
Which
that's
is
my fault,
incarceration?
because He's in jail.
That's exonerated.
I mean,
I think it's 3, Judge.
The last hearing, I argued that too. That's what when they're in custody, that falls under 3,
that's what I thought, yeah.
not 5.
Let me see.
but it's beyond their control. Well, I guess if they don't get themselves rearrested again. I'd have to look at that one, Your Honor. That my gut reaction is that the incarcerations fall under the one that specifically addresses incarceration, and that's subsection 5A5. And
Okay, well, got you at any time.
3 does too, don't you think?
Yes.
yeah, it says must be shown under the subsection 3 must be shown that his failure to appear arose from no fault on his part. Well, he got himself rearrested outside of the jurisdiction of Jefferson County. That clearly shows fault on his part. But frankly, Your Honor, I've not sat down and looked at that.
We'll just take that on the advisement.
Okay,
We won't make a rule on it right now. We just take it on advisement and research it.
Right.
And
it wasn't a rearrest, he was just sentenced.
14 months, it says it right there.
Okay. Yeah. So he already had charges pending against him in Hardin County. Let me, again, Your Honor, I would still like to take that one under advisement. Let me look at it.
okay. Okay, who's next?
James Hunter, Judge.
Hunter. That's 236CCB 0354. Let's see, Denise was on July 5th, 2023. He was rearrested 12/1/2023. That's what I have on the docket.
Right, Judge,
Is that
our
correct?
records show that he was arrested outside of the 10 days after the capias issued, and the capias was issued 10 days outside of it being asked for.
Well, okay,
I'm
Could you-
looking at section 2305.
Could you-
Judge.
okay. We're gonna have that pull up his, okay. What was it? When was the capias issued? Go, could you
I
check?
think-
What's the case number?
I'm sorry.
This is on Hunter, M333144. The capias was entered in this case. Probably was after, sometime after July 5th, 2023.
What's the gist of it?
The gist of this case is that if the warrant's not
Yeah.
issued in a timely manner, you have procedure under 1719 to have it issued. And if you do it under 1719, then you've got you've got a claim for remediature or affirmative defense to liability. But otherwise, there's nothing in the statute that provides for a reduction of interest or otherwise any changes to the amounts incurred, is what it is. There you go. That's a highlight.
Does it have anything in
You
it?
talking about the leasing, the KPS for the bond forfeiture or?
Yeah,
Because basically they argue that the KPS had something to do with that it was entered too late.
Okay, they got 10 days to issue the KPS and another 10 days to enter it into a local system, and it wasn't done.
it wasn't?
No, sir.
Well, Your Honor, that's what the argument is, but here's a case right here that specifically addresses that 2305.
Okay. What does it say?
Issue.
It was issued on the same day, July 14th?
Did I give you a copy? I gave you a copy of the case.
I gave it back.
You
I
gave
didn't
that
know,
back?
if you-
Oh,
I thought
okay.
you just let me look at it.
No, I was handing that one to you, Your Honor, because that's what they're arguing.
That was on July 19th?
Well, that's when it.
Sheriff of Reach County shall enter a KPS issued under this article into a local warrant system. Not later than the 10th business day after the date of the issuance of the KPS by the clerk. So the clerk issued it when?
July 19th.
July 19th. And, I guess it went into a database?
So
On the
the
same-
forfeiture date was June 26th. The NEC was not done until,
Which one are we talking about?
You talking about Hunter?
James Hunter Jr.
James Hunter.
We're showing a NEC date of
July
The
5th.
The NEC date and the forfeiture period date's not the same.
Okay.
They weren't done at the same time, so it was actually a failure to appear on July 26th. You called for a
Okay,
June 26th.
June
June
26th.
26th.
Okay.
And so after that, the NEC wasn't done until
they didn't do the
July
lease
5th.
until July 5th?
July
Okay.
5th, and the warrant wasn't there until July 19th. Or capias wasn't issued until July 19th.
Right. And it's,
Oh, wait.
and that could be true, because they were behind.
Yeah,
Oh,
that was
that's
in the
14 days,
Odyssey.
that's 14 days.
Yeah, the warrants weren't issued, and it was the Odyssey situation, but
Right.
we were getting punished.
Oh, I
The
see what
warrants
you're
weren't
saying.
getting put out there.
I see what you're saying.
Is the reason we have this issue. It wasn't anybody's fault per se, except that Odyssey was
Right.
an
It
issue,
was the
but we
computer
were getting
system.
punished and no warrants were getting put out there, and now we're here, still getting charged interest and everything else.
Your Honor,
Okay.
the case that I gave the court and highlighted the latter part of that section, they specifically addressed 23.05, and that's actually C. But if you look at C, it's whether or not the timely issue of the capias is under C, where D is the entry of the warrant into the local database. So they're basically the same. One is the court does, and the other one is done by the sheriff's office. But if you look at the analysis that the court goes through, it's saying, look, there's nothing under Chapter 23 of the Code of Criminal Procedure that suggests that the failure to timely issue a capias causes any reduction of liability in the forfeiture. And that's what we're already here. In fact, if you notice in a footnote, that footnote 4 there, it goes through the analysis that if the bondsman does want some sort of relief, then they can file a motion under section 17.19 of the Code of Criminal Procedure. And under that section, they can then ask for the court to enter a warrant, and then they'll have the warrant. And if the court refuses to enter the warrant, then they've got an argument that reduces their liability or eliminates their liability. That's an exoneration. So the burden is on the bondsman to do something more under 1719. It's not that we then turn around and say, oh, the capias wasn't issued timely enough. No, the bondsman is to get the criminal defendant in front of the court. And when they fail to do that, the burden still stays with them to make sure that all this goes through. If they don't, if the capias was never issued, if the warrant was never entered within the 180 days, that still does not exonerate them, because the court goes through and analyzes it and says, look, section 22.13 specifically specifies what will exonerate the bondsman. It does not include failure to issue a capias, does not include failure to enter the warrant into the system. That's where you have to go back to 1719. So what they're asking, or they're saying, is they're being penalized, being charged interest when the capias was not in the system. There is nothing under the law that would provide for any such relief. It just simply does not exist. Their relief is to do 1719 and ask that the warrant be issued themselves. So that's the argument on that, Your Honor.
I would
Okay.
argue that the court's discretion exists for exactly that kind of case, Judge.
There is no.
That's what the rule exists for. And if things are going to happen that far outside of the rule, that's where the court has the authority to exercise its discretion to remedy a situation that isn't the fault of the bondsman.
Okay, but I think what he's saying, that even if it's the fault of the sheriff, or, well, I guess in this system, in this case, it'd be the fault of the computer system that the county has that caused them to issue the capias outside of the 10-day window, which I guess it was 14 days, because it was 14 days after, it was after the forfeiture, I think. And so, but what he's saying, even though even in that situation, there is no remedy other than the remedy that's cited in the case, which is Article 17.19.
Your Honor, and I'd also add to that, that section, Article 22.13 is not discretionary. It says the following causes and no other. The court is limited to what's specifically enumerated under section 2213 for purpose of exoneration or
Okay.
making adjustments. It's not under section 2216. It's under section 2213, and under that section, the court doesn't have discretion.
Okay. Okay, Mr. Kelly, what's your response?
First, Judge, is that it is a pretty novel issue in that it's not like it was human error, right? So not, for example, that the court had a bailiff's call and then forfeited a bond and then something just physically sat, right? It's not like somebody just sat on it and didn't do their job. What was happening is the county was going through a technological transformation, and it seems as though if that entire process had happened 6 months earlier, then we're probably not arguing this specific case to you right now, Judge. But it seems that the alternative to that is because the county went through a technological change and the interested parties perhaps weren't aware that this was happening, right? My assumption would be that may not be the safest thing to do, but the natural assumption before technology kind of took over the way this worked was there's a bailiff's call, right? And then a bond is forfeited. And then everybody walks out of court thinking that the next 2 or 3 steps that generally happen are about to happen. The capias is going to be issued, and then that person's going to be arrested, and then we're back here the next few days or the next week or whatever. And all the normal things that always happen in that process happen. But it seems like here, the parties that would have interjected themselves into the process to say, hey, Judge, hey, Your Honor, the capias hasn't been issued. Hey, Judge, the capias hasn't been entered. So it's not an inaction on the part of whomever seeking a remedy. It's an I didn't even know because of, I guess, what I would call kind of not a 1 in a million situation, but certainly something that is generational. I mean, how many times has the county made such a technological change that I can even say, and I think Mr. Price, all of us could, was kind of a pretty wild 6 or 8 months for a lot of us, especially guys and gals in my field that are, trying to do discovery or having to adapt. Frankly, it's been helpful, but the adaptation took some time. So what I would argue to the court is that this is different than whomever it is seeking the remedy just sitting back and saying, well, 10 days here and then 10 days on the second part, and we'll just figure it out later. If they'd have known, I think they would have interjected themselves into the process. Say, hey, again, Judge, the capias hasn't been issued. Hey, Your Honor, it hasn't been entered. That's the argument.
Let me ask you this. Now, when did the bondsman, was the bondsman put on notice anytime after the capias was issued?
What do you mean?
Let's say
May I ask Mr. Romano one quick question? When did y'all learn that James Hunter had missed his court date?
We knew pretty quickly. Now, when we found out about the warrants not getting entered in time was the bail bond board meeting that happened. And it got brought to the attention of all of us bondsmen in the room that the warrants weren't getting issued. At that point, I started checking. I mean, I had to go to all the courts, and what most courts did, and not all, and I'll use one example, Judge Stevens' court. I had 100,000, and what took place was they finally just issued an at-large without proper bond because they couldn't get the capias done and the warrants done. It was an issue with the system. It wasn't the clerks. It wasn't Nobody understood how to do it at that point. So even doing a 1719, like Mr. Price is saying we should have done, wouldn't have got a warrant done. Everybody was having issues getting warrants done. It wasn't like nobody wasn't doing their job. Hell, people weren't properly trained.
Okay, so you're saying that, okay, just to pick up on what you said, you said that even if you would have asked for a warrant to be issued under 17.19, because of the system failure, it still wouldn't have been issued.
No,
Is
sir.
it- that's what
And
you're saying?
There was only like a short window there, like 3 or 4 months. Yeah, I don't even know if it was that this happened. I mean, the courts were having issues getting warrants done, and it wasn't their fault. It was the system. That's why these weren't getting done. This
Again-
never happened. I mean, we've been here a long time, Judge. Usually somebody forfeits a warrant's issued within day, 2
Yeah.
max. I mean, that is historical. That's how it's always been. And it's back to that way now. There's no more gonna be of these 2305s here in probably another docket or two, because there was only a short window it happened, but it was because of the Odyssey changeover.
But the relief they're requesting, as I understand it, is they don't owe interest on the bond during the time period between the issuance of the capias and the time of the
Let me ask you
forfeiture,
this here,
which,
if they would have, let's say the capias was issued on time,
right,
within the 10 days, okay? How would that have affected them?
I don't think it would have.
Okay,
I don't think it makes any difference at all. I think they've got the guy rearrested in this particular case. He was rearrested within the 180 days. And they're simply arguing about interest from July 5th through, what was the capious day, July 19th? 2 weeks of interest is what we're arguing.
that's
here,
what you're
Judge.
arguing?
That's what I understand. Correct me if
Oh.
I'm wrong.
On
On
Hunter?
Hunter.
So how many days did you just say?
I just said July 5th, the date of the judgment nisi, which is the date that starts the interest running, through the capias of July 19th.
19, 14 days.
Yeah, but
That's
he
2
was
weeks.
out for 158 days, Judge. Who says in them 14 days he didn't get stopped in a traffic stop, and we're not here today?
But again, that's what 1719 is specifically for. I mean, the law squarely places the burden on the bondsman to ensure that the person that they guaranteed to the court would be here on the day that they're supposed to be here has an opportunity to go in and say, hey, look, you've not gotten this complete, Judge, please enter this, issue a warrant for this guy, and it gets done. I mean,
It wasn't the court's fault the warrants weren't getting done.
But that-
Odyssey was. They
that
couldn't do it.
doesn't change 1719, and there's no alternative procedure. I mean, because literally the capias could never be entered, if for whatever reason that it not get entered or whatever. They have to come in here and say 1719 that the capias wasn't issued, that the warrant wasn't issued. They have to come in and say, Judge, they need to come to the court to get this corrected. You can't retroactively say, oh, well, now we just finally figured it out, so we want retroactive changes, when the law does not provide for that in any way, shape, or form. It simply does not allow for it. It's strictly, it's court cost and interest, and so we're fighting over. And I've not seen any that's significant interest, but we're fighting over interest on relatively short periods of time, in my mind. I mean, the fact that there wasn't a warrant, that could be the case in any case. And the law does not, and that's what I'm saying about this case. They specifically address that and point out that the burden is on the bondsman to go get that warrant. The burden is on the bondsman to make sure that everybody in the process has done what they needed to do.
Okay,
So-
so how could everybody in the process do what they were supposed to do when they couldn't because of the system? It wasn't human, it was the computer issue. 1719 is a warrant, same as a capias.
You can
It
check,
couldn't have got done.
even during that time, you could check and see whether or not your guy had a warrant on him, could you not?
Yeah, but
Okay.
how's it gonna get issued for us to remedy doing 1719? How would the warrant get issued if it wasn't being able to get done because of Odyssey?
But that's when you come back to the judge and you say, Judge, we can't get a warrant issued for this guy. We're entitled to relief. That's what the law says. That's not, It's not that you get to back into it and say, oh, by the way, Judge, there was a couple of months there that were bad, therefore we should get interest-free bonds. I mean, there's nothing under the Code of Criminal Procedure would say that they don't owe interest on their bond. It's simply nothing that I've come across has said no interest on the bond for this period of time. So this is a made-up remedy for a
But I
problem
think,
that's
okay,
on them.
but I think the issue is, even looking at this case, is what recourse does the bondsman have, even if he wanted a warrant, went to the court for a warrant to be issued, and a warrant still can't be issued?
I don't know that there was a time that a warrant could not be issued.
That's what they're saying.
But
It
that's-
could not be issued
No.
with the Odyssey
you're-
system. That's
So
what they're
you're saying
saying.
that no warrants were issued by Odyssey from when to when?
We don't know
So-
that, we don't know the exact window.
On, as far as your goes, as far as what you're saying, what day did no warrants start happening to when warrants started issuing?
We don't know that window. You're saying we should have notified the court. We don't know what window it was falling in.
But
You know whether or not your criminal
but you-
defendant
but-
has a warrant.
But you're saying that you went to a bail bonds meeting,
Yes, sir, it was brought up.
and somebody brought up the issue about them being unable to issue warrants because of the Odyssey system.
Yes, sir.
And so it was during this period of time.
Yes, sir.
Okay. So it was somewhere in this period of time. We don't know exact when to when, but we do know, at least from looking at the information that we have, that the warrant finally got issued on the 19th.
Yes, sir.
Okay. We don't know when it actually started, but we know at least in this case, when it ended, at least they were able to do it on the 19th. Is that correct?
July, yes, sir.
Right.
The one before this one is in May.
I mean, yeah.
So there was warrants issued in May and there was, yeah. That was the NESI was filed then. When was the warrant issued in February?
May 31st.
Okay, so that one looks timely. Well, maybe 5 days late, I don't know. Can't do my math. But Your Honor, so basically, I mean, but they're asking for relief that's not in the Code of Criminal Procedure.
Okay, I'm gonna take this up under advisement,
All right.
kind of look a little bit more
So
into this, man.
1719 is also, is before forfeiture. Your Honor, it's a warrant before forfeiture.
But it said, but specifically, this court addressed 1719, the Texas Code of Criminal Procedure entitled surety may obtain a warrant. So you can obtain a warrant at any time was what this Court of Appeals is saying.
So Judge, if you forfeit a bond today,
Surety may
can I come
obtain.
in tomorrow and give you a AFRS?
No, I mean, if you fall,
1719.
yeah.
Yeah, it says that the court refuses,
That if the court refuses
it's an affirmative
Yeah.
defense.
to issue the warrant,
Mhm.
and then of course, I mean,
And again,
the bondsman is gonna be affected by that. And so I can see why the bondsman would be able to argue and get relief.
but number one, it puts the court on notice. The first time that you heard that there was any issue with the capias was today, I'm guessing.
Yeah. I mean,
Well, no, but you see my point. My point being, you're the judge of this case, and the first time that it's been brought to your attention, and actually just
oh yeah,
recently
you're
was
talking
brought to
about
my attention.
by the bondsman, right?
But no, by anybody,
Mhm.
by anyone that it was brought to your attention is.
But I do
today.
know this, that we've been having problems with that Odyssey system since we've had it.
Right, it's taken
Yeah.
some adjustment and learning
Right.
process, and there's a learning curve, no doubt about that.
Not that, but I'm just saying that system just, you're unable to do things on it.
That,
It doesn't have anything to do with human error. It just, I don't know if it's in the program, I don't know. But sometimes sometimes the system is down. That's all they tell us is the system is down. And we are unable to do certain things until the system comes back up. So I'm hearing from him, he was told in a bail bonds meeting that the system was down, I would imagine.
Yeah, there was a backlog. I mean, I don't.
And that was coming from the, I guess that came from the clerk's
Who did
office,
it come
because
from? Yeah, that's,
it must have came from the clerk's office, huh?
Who brought that to the home? Remember that here, that conversation?
I think it was just something that just came up in the meeting about, I mean, you know, I got one that's 20 days, one that's 42 days.
Because I know that it used to take, y'all have a court reporter in the bail bonds meeting?
I have to go back and look, and it's gonna be sometime around this time.
Yeah, we could look
last
at,
year.
okay, we can, probably check the court reporter's record and see, you know, what was said, what was going on, and we could at least have a better idea. But at this time, the court is gonna take this matter under advisement.
I think
Okay.
that's the rest of them, isn't it?
Would you hold Mr. Singletary's?
There was
case
two of them.
also? Yes, Judge Singletary.
Singletary.
Singletary and Hunter Jr.
Right.
Is that gonna apply?
Yeah, it'll be cemetery and Hunter. That'll be under advisement. Okay. Is that it? Y'all have anything else?
I don't, Judge.
Okay,
Be excused, Judge.
yes, you may be excused. You have a blessed day.
Do we do what? Scott? Yeah, we marked Scott off. I don't know, why did Scott go away?
Scott, was that the first
I
one?
think that's a 2216, that's.
Yeah,
Yeah, I marked it off.
Yeah, court costs and interest.
Court cost plus interest.
right.
Oh, okay. Yeah.
Mr. Reed,
Yes, sir.
what case
We're-
you here?
We're here for the same thing, just interest only,
On what?
that
What case?
we're five of them.
You said all of the cases that's on the docket?
Six of them. That's six of them. Yeah, when we're talking about the system, we have one here that's like 53 days. It went without a warrant.
Before they issued the warrant?
Before they issued.
Which case is that?
Before they issued the NEC and the warrant.
What case is that? We have also Barajas has two cases. Then we have, Karen, is that
I have,
Sarah?
I should have the NECs and everything. And the warrants. that was issued.
Ledesma,
Let's
Giannis,
see, the case is.
Barajas?
Yeah, 332068-0.
Okay,
oh,
that's.
6-8. Oh, that's Barajas, yeah.
Yeah, and then, 332068-1-0.
What's the name on that?
What was that?
Same name,
Same name,
yeah.
332072.
That's what I have for Barajas, the second case.
And wait a minute. Okay, go ahead. It's hard for me to read that. 2, 3. No. 332068.
That's
All
one.
right, that's one.
332072.
Okay, that's the
Yeah,
second.
all right.
Okay.
Okay, and those went 53 days,
Both of them?
yes.
And what was the,
So, something went wrong in the system, wasn't all, of them,
Could you pull up
all
one of
them.
those cases?
No, I had cases, if you want to see the cases and everything.
Yeah, I was gonna get her up.
yeah, I'd like to keep this.
That
I
it?
mean, since you haven't shown this to us before now. The case was issued on the 23rd of June. That's on,
23rd of June, that's a
Yeah.
month after the, you say May 1st? Okay, the NEC was issued, it was the bond forfeiture was May 1st, the NEC was
Yeah,
June 22nd?
We would have the bailiff's home and they would have to send them down to the county clerk's office.
yeah.
Right,
And they were preparing these at that time.
Okay.
But they were having issues, I do remember that.
I don't
Judge,
know.
for the bondsman, it's easier to arrest these people immediately after they miss court than it is months
Right.
down the road.
Right, but
It's
if
hard
if
to do that.
if the clerk's office had problems issuing,
Yeah, but it says the date of Nisi.
yeah, the clerk, apparently the clerk had problems with the computer system issuing the capias.
Yeah.
And
Your Honor,
so,
on this one case right here, we're talking.
which one? Barajas, which one of his cases?
Rojas, we're looking at 072.
Okay, okay,
All right, 072. The Nisi date is 6/22. The capias date is 6/23.
Yeah, yeah, you can't issue a warrant.
So it's one day of interest is what he's complaining about.
No, that's not. This guy knows how to turn words around.
okay.
It's not, it's the date that the Nisi and the warrant should have went out immediately after the forfeiture.
Right. Okay, I
And
understand.
that's what we're arguing, that immediately after the forfeiture, because, and then it takes longer to arrest these people when they've been out way past the forfeiture.
But as I understand, your request for relief is,
Just the interest, that's all.
and the interest we're talking about on that case, that 072 is 1 day.
Okay, so that's what you're charging us, 1 day interest?
No. it's-
Well,
He's saying,
one
he's
day-
saying, he's gonna take off 1 day of
It's 1
interest.
day interest.
He wants to take
Well,
off
no,
1
I
day.
mean, it's,
Man, I mean, you know, for
It's
1 day
really-
interest, I wouldn't be up here.
well, that's what it is.
No, that's not what it is.
The Nisi date is
That's not-
6/22.
We're just trying to get relief of
Let me
the,
ask you this here.
of the interest. That's
Oh, you
all.
want all interest gone?
Yes, that's what
Oh.
we're up here for.
Okay, I thought they were just talking about
No,
some
no,
other,
no.
all interest gone?
Yes,
Why?
because of the lateness of the Nisi and the lateness of it's not our fault. It's the county's fault. So
It's
why
your-
should why should we take the brunt of it when it's not our fault, when it's the county's fault? That's what we're talking about.
Because it's your
Now, look, if the
responsibility.
judge wants to give us the relief, fine. If he doesn't want to give us the release, I'm okay with that too. I just think.
Your Honor,
there should be
there's-
Well, just let me ask you this here. Now, your hypothetical.
Well,
Let's say that-
my-
Let's say that bond was forfeited 1 day. Capias issued the next day. The day after that, he gets arrested.
He was
Yeah.
rearrested
Okay,
in July.
I'm just saying if
2
they,
weeks later,
Yeah,
2 weeks
Okay.
later.
if that was the case, I wouldn't even be here.
okay, I'm
Well,
just saying, what would be the
we
interest
are
on that?
fighting, Your Honor, the interest on this case is $4.11 is what we're talking about.
That's not what we're talking
No,
about.
okay,
What are you talking about?
he's saying that,
Well, interest.
okay, are you saying that, the total interest is $4.11?
Isn't that right? Yeah. $4.11. I mean, this is a court cost plus interest case. The guy was rearrested 7/3 of 23. He was arrested 2 weeks later. He's talking about $4.11 on both cases, Your Honor.
But I'm talking about,
I mean-
we have 6 cases here.
Okay, but we talking about
These
these
two- I
two,
think some of them are like-
Barojas.
$80, you know?
Okay, but on the Barojas case, let's stay
Yeah.
on these two cases.
Yeah,
We talking $4.11.
$4.11.
Okay, you have a problem with that?
no,
Okay, so we'll go to the next
So,
case.
right.
if he doesn't have a problem, I mean, but what about the other ones that's more?
Okay, we're gonna
Well,
address each one of them one at a time.
Okay.
Okay. So Barojas,
yeah.
what about this? What
Again, Your
Patty?
Honor, I would point
okay.
out that none of this was brought to the DA's attention until today. None of it. I mean, actually, Keith Day, I'll give him kudos.
Yeah.
They sent me a list of their cases, but they're the only ones. So,
Okay.
you know, I mean. if
Y'all
they-
could have worked
if
them
they're-
out before y'all
If they're
got here.
looking for relief, they ought to ask for some relief. you
Yeah.
know.
No, he said he wasn't, he said, according to Keith, he wasn't gonna give us any relief on the interest that we had to come to court with it. We tried to ask him for relief on the interest. He said no. According to Keith Day, which is our representative.
Well, and
Make sure.
Sanders reminding me that what Keith was talking about was the interest from the date of the Nisi to the date of the Capias. And now you're in here saying it's from the Nisi, I mean, it's entirety.
No,
Right,
no.
So we have one.
that's what,
days, and we're supposed to be asking for no interest of the 42 days prior.
Just that window.
that window.
Right,
from the
okay,
date
I
of
just
the
wanted to
forfeiture
make sure,
the day
because
of the
Yeah.
days that weren't actually came out.
I think,
Okay.
like, in Al's situation, he's wanting interest.
No
on
interest.
Because it was took too long, but y'all were asking from the interest clock to start, instead of the Nisi date, to start when the
Right.
KPS was actually issued.
Right, we're not.
And that's what Quentin thought all of that was for. So I'm just saying,
Yeah.
like, with what you're saying, Mr. Reed.
But he turned that down too.
Yeah.
But
Yes,
number
he
one,
said
you're kind of
budgeted.
talking about just minimal amounts. I mean, you're talking on this one, it's $4.11.
Yes,
And even on Keith's cases,
Yeah,
we were talking about
I have
nothing significant. I mean, it was really nothing significant, Your Honor.
Okay. Okay, your next case is that Patty Altz, AULTZ, cause number, NICI number is 23 CCCB 0264.
What is it?
Well, it's, the criminal number is 333470.
What's the name, Judge?
Patty Altz,
Oh, okay, I have that right here. Okay. All right.
That not your list?
I had one just like it.
Oh.
That I can't really read that.
Right, I understand that.
Okay, what do we have? I don't want to talk the judge's time any more than we have to.
you still looking at for Altz?
No, I haven't.
What's your complaint on alts?
The
The same complaint on all of them. It's on all of them.
All of-
It's the court cost. And it's the court cost. Just the court cost, that's it. That we should be charged just the court cost because of the lateness.
So you're saying no interest?
No interest, just court cost.
And what's your argument?
Because
On
of
that.
the lateness of the NICI and the lateness of the warrant. You got one that didn't go out for 53 days. And another one didn't go out for 44 days and 35 days, 23 days.
Okay, and all of those was due to computer error, and the county clerk's office is had the responsibility to
But
issue.
that's my argument, Judge, and whatever you decide,
Okay, well,
I'm
the
gonna walk
decision,
out here-
the decision will be based on the law. It's not gonna be based on just some random guess. It's gonna be based on the law. Now, let's see, now the state, Quentin,
Yeah.
what is the state's response?
Your Honor, again, we're looking at interest on this one, on the alts of $15.62. Again, back to what Keith was talking about again. And I don't even know what the days was that was
Let me
left.
ask you this. Does that interest, how much of that interest includes from the time that the bond was forfeited until the time that the capias was issued?
I don't know when the capias was issued, Your Honor. On that alt
I mean,
case.
can we figure that out? I mean,
We
it's
can.
in the system. I mean, we need to look at those days.
I think I have it here. We have, let's see, we're talking about 1562.
Cause you said it was 50,
$4.11 for those two, $82.85 and $82 and
Now,
And
that full
36.
amount of the interest that you just
Yeah.
quoted,
Right.
is that from the time that the bond was forfeited until the capers was issued?
No, no,
It's
no,
NEC. The amount we calculated on the 82 is from the date of the NEC to today. Or
Till today?
Sorry, to the date of rearrest.
Yeah.
I'm assuming those were.
To the day of rearrest?
Right.
The date of rearrest.
Okay, but you saying that you have a problem because because the capers wasn't issued within a timely fashion within the 10 days, that
Exactly.
you should be relieved of all of that interest.
And that's, he likes to talk about the law and says it should be, the NEC and the warrant should be in a timely manner. Well, I'm saying it wasn't in a timely manner. We
Yeah,
should have
but-
some sort of relief,
Yeah,
but
The law provides 20 days to get the capias and the warrant, the capias issued and the warrant entered in the system. I mean, the law, it's not,
10. Yeah, 10 for the, okay.
yeah, I mean, there's 20 days there that,
we have one here 53 days.
He said
and
one.
I understand
One
that one,
44 days.
which one is 53 days?
The first one that we argued,
Oh, you talking about Barras?
yeah,
That was the first two.
Yeah, and
32, yeah.
the $4.11
Yes,
apiece.
What I'm
Again,
saying, what I'm
he's
saying
talking about
is, it
from
wasn't
the
issued in a
12.
timely manner. We have 5 of them
Right,
here that
right.
wasn't issued in a timely manner.
But the total amount of,
But I was just making sure
mhm,
that we're.
Yeah. I think so. That's why I've got you to make sure I'm saying it right.
Okay, so now when did you calculate the interest?
We
From
ran
when to
from the
when?
judgment NEC date to the rearrest date. So it's June are we still on Baharas?
Well, we,
No,
no,
we
no,
got-
we,
All
oh,
of
yeah.
them run from NEC
Yeah.
to rearrest.
Right.
NEC to rearrest. I mean, because that's what, 215, 22,
But there's a period of time
13.
from when the NEC was entered until the capias
I don't know that.
was entered, that he did not have notice that the person, I mean, how do we know he had noticed that the person forfeited his bond?
Did you know? Did
Do
you
we
know,
know?
did you know that your criminal defendants didn't make
Yeah,
their appearance on the
Sure,
day?
we sure we know,
Okay,
but
so the bondsman
what-
knew.
what can we do about it? We can't go get him.
Okay, he was served with
Right.
the NEC?
We
Right.
can't go get him without a warrant.
That's, okay.
But they knew the day of, and again, that's where they go to the court to seek relief. But looking back at, now I lost my train of thought. Must not have been that good.
They can't go to court, seek relief if they can't get the capias and the warrant out through the system.
Because the system was down.
That's right. And what he was quoting last time was get off of to do an AFRS, not after the forfeiture is already done. On that 2019 or whatever.
Well, again, that's what the
Yeah,
court.
1719.
That's
So what
what
he's saying is that it was impossible for him to
they've done anything.
do anything
Right.
because the system was down. He couldn't
Right.
get it, he couldn't get a warrant either way.
Just asking the court is to be fair. Whatever the court decides, I'm good with it.
Well,
Again, Your Honor, I would refer back to Todd versus State. And in that case, that's exactly what the court said, in a pre-default situation that or pre-judgment situation anyway, that the surety does have the opportunity to go before the court under 1719.
yeah, but
And obtain a-
even if he has the opportunity to go before the court could not issue a warrant if the system was down.
But at least we would know. I mean, I'm not even sure.
I mean,
when
that's
these
just
other
like.
cases- I mean, well, Your Honor, but back on what we were, and again, whether we're talking about total interest or just the days of interest between the capias and the NEC, the last one was 1 day.
I understand that. I
literally.
mean, okay, but we're on this
So,
case.
Well, but I mean, I don't know.
What
when
would be the time? I'm just saying,
I don't
you're
know.
talking the 53 days, right?
when
It was
the
it was
capias?
one,
Yeah, 53 days,
But that was on-
44 days.
that was on
35
Baharas.
days, 23
Was the
days.
53 days.
Yes.
For hearts.
Yes.
All right. What about alts? When was the capias issued?
It was 11 days
Could we-
for the
could you
Nisi,
look up,
14 days for the warrant. So see, that one was in a timely manner. So to
Alts?
speak, and we was able to get that defendant back in jail.
Oh, so alts
These
was in
other
a
ones-
timely manner?
The other ones wasn't in a timely manner, so, you know, it just takes
Again,
longer.
I don't know the other ones. You're saying this. that's
He's
the
saying that was
Saran-
alts, but then he's saying that, he has,
Saran.
is that Ledesma?
I've got
Yeah.
Saran, yeah, Saran had two cases, Nina Saran.
Right.
When was the Nisi, I mean, when was the
Could you look
capias
up,
issued on Saran?
Clause number 333
It took 44 days to
952 and 954. Those are the two cases.
You're right, a failure to appear. Right, not from the Nisi, right. Mhm. I want to point out,
Failure to appear was April the 11th, 23,
April 11th,
23.
okay.
okay. And the capias?
You got that? Look
The
up,
case
it was
is,
a, fair to appear was April 11th.
3rd day of August?
And,
When was the case?
No.
When was the Nisi after that?
okay, this is five.
31st day of January.
Okay, write that down.
No,
Mhm.
it can't be that.
He
'cause
said
the rest
the
was
bond
10.
forfeiture was on the 11th. And the Nisi,
Five.
okay, 525.
No, it wasn't right.
And then when was the capias issue?
Are we talking about Saran?
Yeah,
Is it?
Yeah.
525.
When was the capias issued? On the same day?
It was July 19th, arrested in Hardin County.
Let me see that. What you wrote down?
and that's on 952.
That's on both of them. Yeah, they probably the same day because
Not the same day, at least the Nisi dates are different, but I don't know.
we
whether-
didn't have this,
33.
we probably heard these cases on the
Same
same day.
day?
We usually keep them on the same docket.
Oh, okay, so it may be the same.
Well, she can check,
Okay,
but apparently,
Six of them. Both.
954. The next step is.
yes,
Okay,
Yeah.
thank you.
okay. But the capias, same day with.
Okay, the Nisi was signed on May 25th,
right,
2023.
on the second case. That's on Saran's second case, the 954.
Yes, sir.
That's, huh?
206 is the 9, is 526.
526.
The.
526, 26.
Okay, what you have?
DC was signed on 556.
Oh, okay.
Oh, which one? What case?
954.
So it was on the 26th?
Yes, the bailiff.
When was the bond forfeiture? Was that on the 411?
Yes, sir.
On both of them?
Yeah.
411, yes.
No, yeah,
411.
both of them was
Yeah,
411.
411, yeah, both of them. Arrested July the 19th in Hardin County,
Arrested July 19th.
in Hardin County, yeah.
See, we don't know that, Your Honor.
Okay,
Well, no, I mean, that, Mr. Reed has never provided that information to us. We show rearrest date of November 2023, November 10th, 2023.
November 10th. I don't,
Probably in Jefferson County.
oh, when they probably extradited them back to the county, maybe from another
We
county?
don't really see that anymore like we used to.
I know under this new system on the Odyssey, we can't see a lot
Yeah,
of
we don't
stuff.
have
Right, we don't have the metro notes to see
Right.
if they were arrested anywhere else. So
So
it's on the
without us
bondsman.
knowing if they're in another county.
We don't know it.
So, yeah, it was arrested within the 300 days.
That's why I'm trying to stress it's on the bondsman to tell us
Okay.
these things.
All right,
Okay,
here's the,
so that's gonna change the interest? Okay,
here's.
What, the capias was issued the
Right
same
here.
day as the judgment Nisi.
Hmm.
Well, I mean, it's good.
Was the capias issued the same day the judgment Nisi?
Yes,
I'm
on both.
checking with her.
Okay, yeah, I mean, that's what I wrote down a minute ago, was it? But anyway,
Is it May? No, we talking about the second the capias after the Nisi.
he's worried about all of it.
No, what I'm saying is,
Oh,
The only.
you're saying that the
Is
The
it-
next one I see is January 31st.
No appearance.
Yep, there should have been,
Yeah, see.
it wasn't a capias issue?
There had to be a.
It had to be because he was arrested July 19th.
It's not.
Yeah, you guys have November the 10th.
Right.
Yeah.
So all I see in his property is a check is from February of 2003 and then another from January.
No, that,
Was there only one, did you check
Two.
both cases to see if there was?
yeah, check both
Because
cases.
it may be that it only got entered in one
Okay.
case. I don't know. I'm just spitballing here, Judge. I have no
Okay.
earthly idea.
Okay,
Two cases.
They're not showing a capeness in one of them. Not showing it either.
See the.
Can you-
It says the warrant was issued 5/25.
5 point, okay. So how?
that's the
that hap-
Nisi was 525?
No, that's,
Yes.
That's, yeah, I have written down here that a Nisi is issued on 525. Was a warrant issued on that same day too?
Yes.
And then it was issued the same day.
Yeah, they normally do.
Yeah. So that's the capias.
okay, the way, yeah.
So the capias issued the same day, so it wasn't a problem with 10 days on this here.
I don't.
The
yeah.
problem, I guess, what he's saying is on this one, you had the bond forfeiture,
Mhm.
No, I don't.
April 11, and then you had the Nisi, May 25th.
Right.
I don't have any issues on the 10-day of the Nisi.
Okay.
And the Nisi and the.
Okay.
None of those pertain in my case.
Okay,
I have no
okay.
issue. My only issue was, the interest, okay, just some relief on the interest, but
And the interest you should get relief on the interest,
they have.
and for what reason?
Because of the lateness of the Nisi and the warrant. You know, it's not in a timely manner as the law provides, a timely manner.
So you're saying that the Nisi,
53
because the Nisi was issued,
53 days is not a timely manner, 44 days is not.
where you get 53 from? Because it looks like if,
Because it took 53 days for issuing the Nisi and the warrant.
no. If the bond forfeiture was on April 11th and the Nisi was issued on May 25th, that's not 53 days. That's more like
Are we talking about the same case?
30,
30,
it'd be about
44.
45 days,
something like
44
that.
days, something in that.
Yeah.
That's this case.
Yeah,
Sure, 44 days,
Saran, right,
44 days.
right.
The other one,
No, we could
50.
just take dealing with
Okay.
one case at a time.
oh, okay.
Yeah, you get kind of confused, okay.
Your Honor, on that, I would argue the law allows for 20 days. I mean, it says must in there, but the law allows 20 days. It's not, his argument is boy, if we had that Nisi, that warrant and capias and all of it issued on the very same day that the defendant doesn't show up, then it's easier for us to run over to their house and
Right.
grab them
Right,
right then and there, because we
Right.
got the warrant, we've got everything, we can go get them. The law provides for 20 days. The law doesn't give them, I mean, it provides for a delay of 20 days statutorily, 10 on each, between the.
Okay, but if he missed a delay of 20 days, and this 44 days, so there's 24 days in there that I guess he would be
He was shorted,
right.
that it wasn't there. So there's 24 days that it wasn't there. Yes, that is what it's showing. Yes,
Okay. And what would be the interest if you take off those 24 days?
He didn't get charged interest in those days.
Oh, okay,
There is no interest on this until
Well-
May 26th.
on Sharon, you got the interest wrong.
Okay.
Because your arrest date was November the 10th.
Right, I mean, again,
okay, but his arrest date was July 19th,
July 19th.
Right.
so that why the interest would be wrong.
right, under that scenario, but we
Right,
don't,
so you would have to make the adjustment.
right, to July 19th.
Okay, I understand.
But it would be,
This one?
yes, but we need that if we're gonna do the calculations for the arrest.
Okay.
I mean, we need a copy.
Okay,
So yeah, we'll redo the calculations
Okay.
to July 19th now that we know.
okay. Now that's the wrong. Okay, and
They're
now
all
look,
gonna be basically the same.
okay, so what we need to do is just look at all of those cases. You can provide him with the dates of arrest. If it's different from what they have, obviously the interest is
No.
gonna change.
So,
And so that'll save us a whole lot of time. So what we'll do, give y'all opportunity to get together and then y'all can see if y'all can agree on what the interest would be. Okay? Because all of it is the same issues in every case.
Right. I mean,
Okay, we'll
Yeah.
do that.
okay,
We'll give y'all time to do that.
all right.
All
okay,
right,
we'll shoot you on that, one from Harmon County.
All right.
okay.
Send that to us. And are any of these others? No,
He said all of them the same. He said all of them the same.
It's all about the interest, okay?
Right.
But we should get some relief, but we're not gonna get any.
I don't know how you came to that conclusion. I just said, y'all gonna get together and obviously the interest is gonna be reduced based on
the rearrest date.
their arrest dates are different. Their arrest date was
Yeah.
several months later, which
Yeah.
caused them to have a higher interest. So once you get together with them and get the correct arrest date, obviously the interest is gonna go down.
Go down.
I don't know how much, but it's gonna go down.
Thank you so much, Jeff.
Okay, you're welcome.
Have a good weekend.
All right, same to you.
All right, we saved the last one for, the best one for last. There we go. Thank you. You have to keep us in line.
I'm a nice one. Very calm.
Okay, what case are you here on? Is that Simpson? The key date, let me see.
Yes, sir.
He has a couple of cases.
Yeah, but I just want to make sure that you are taking under advisement, I guess, for Bell America on the interest, correct, for when the warrant was issued? That, I have the same argument.
You had the same argument of the last,
So
of the first cases?
we can do, I mean, whichever one you want to start with, really.
Well, but when was
I know
the
you-
judgment? How about Mac?
Okay, on Mac, his forfeiture was May 10th of 23. The Nisi,
Hold on. You're faster than I am.
That's okay.
The judge is probably keeping up with you.
May
Okay.
10th, right?
May
Yes, sir.
10th, okay.
okay, Judgment Nisi was not filed until May 30th.
May 30th?
We show Nisi of May 10th.
Well, it was signed by the judge on May 10th, but the warrant, and it was not, did not come out until May 30th, and it was not filed in the county clerk's office till May 30th.
Okay, so May 30th is warrant and capious.
Right, now,
So, okay. So,
Okay,
but
5:30.
10th, the Nisi came out on the 10th,
yeah,
Right.
but the warrant didn't come out until May 30th.
yes, sir,
Which was 20 days.
right.
Right,
The issue with
within that
this one
window.
is, we had to hire a bounty hunter on him, because he went well over our time, and so I know that's one reason why Keith was bringing it.
When was the rearrest?
Oh, he was rearrested February 27th of this year.
Oh,
Yes, sir.
Why haven't we gotten that cleared up before now?
Well, I let her know yesterday afternoon. I wasn't aware that we had Thomas, our bounty hunter, we brought him to the Jefferson County Jail back in February.
Oh, okay. And then, okay, all right,
Yes.
all right.
Yeah, so she let me know the rearrest date, but they're wanting to resolve the issue of interest running from Nisi date to rearrest is what we normally do, and they want the interest to run from the date the warrant was issued,
Correct.
which is May the 30th. So they're wanting
10 days.
just relief from interest from
10
the
days.
Right.
Yes,
But-
we're
Well,
not,
20 days.
Again,
5, 10,
that,
5:30.
the law provides for
Yeah,
20
20 days.
days, basically for the issuance of the capious and the issuance of the arrest warrant. The arrest warrant was issued within 20 days.
right.
It was entered.
Let's see. So you're saying the 20 days, according to Article 23.05, you taking the 10 days and 23.05 C and D.
Yeah, adding C and D. I mean, the law provides for 20 days in effect.
Right, and it did occur within 20 days.
It was on the 20th day.
Right. That's when the sheriff entered the capias.
Mhm.
So that was, right,
Yeah, the capias was signed that day and the warrant was issued that day.
yeah. 10 days after the court issuance, that's 10, and then another 10. Yeah, that'll be the 30th. Let's see. No, so they did all of that on the same day.
Mhm.
Now, but I guess maybe part of their argument is that the issuance of the order of forfeit, let me see, no later than 10 days after the date of this. The capias. So the capias was not, the capias actually was issued 20 days after.
Correct,
Right. Well, it should have been issued 10 days after.
correct.
And because after you do 10 days and you add the sheriff, then the sheriff shall enter 10 days after.
Correct.
So you're talking 10 days.
At most,
Yeah.
yeah. I mean, I don't know what the,
Yeah, it's not 20, so it'd be 10. Yeah, you should.
well, but what I'm saying is that's a 20-day total that,
I know.
that the law,
Well, but you got 10 days.
statutorily that.
Yeah, but
I
you-
understand. It's
yeah.
the capias was entered 10 days late. But the bottom line is the warrant was entered in the system within the 20 days. I mean,
Right,
the first one is kind of no harm, no foul.
right. So, but you saying if she asking, I guess, relief on
10 days.
23.05 C, that wasn't timely.
And that would be, well,
Well, it wasn't timely. It should have been, it was issued
Well,
20 days later
I
instead of 10.
understand, but
Right.
what I'm saying is, so do we get, like, is that 10 days? Is that what we're talking about?
Yeah, they're asking for 20, but I think it's 10.
I mean, one says it's 10 days, 10 would make it 520, and then give you another 10 on the issuance or the entry of the warrant in the
Right.
system.
The issue
So
was
it's-
supposed to be, the warrant was supposed to be issued within 10 days, and then the sheriff actually enters within the next 10 days.
Okay, so
So, but it was issued 20 days later, and the sheriff entered it on the same day that it was issued.
right.
Mm-hmm.
So you're talking 10 days interest.
Anything that I can get.
Right,
I mean,
Wh-
when you have to hire the, recovery agent, that's extra cost. We
Right.
may not have had to do that if we didn't have the issue with the Odyssey system.
But,
I mean-
but the law provides for 20 days. The
I think
law
the-
provides for that amount.
yeah, but the law provides that it's issued 10 days.
It does.
It doesn't provide that it's issued 20 days.
Right,
It provides that it's issued in 10 days,
but the
but this
effect,
was issued in 20 days.
and you're 100% correct, Your Honor. And it's mandatory. It says must, so it's not optional. It's both of them are must. But if you assume that the time periods between the two of them, you can't get them arrested on a capias. You have to have the warrant entered into the system.
Yeah, but there was issued and entered the same
Right.
day.
But the
So
warrant,
if you would think about that,
the warrant
if-
is what trigger, I'm sorry, Your Honor.
right, if you think about that, if they would have issued and entered on the same day, let's say the clerk would have issued it in 10 days, it probably would have been entered on the same day.
But
And within 10 days, it would have been 10 days instead of 20.
but from a bail bondsman's perspective, they can't arrest the guy
I
until
know.
the warrant is issued.
I know,
And that's the warrant is being issued and entered into the system.
right,
That's what gives them, you know,
right,
everybody the authority to run out and
Right.
pick this person up.
Right, but there was a delay on the part of the clerk's office
Yeah,
that caused it not to be issued in a timely fashion.
the state will agree to reduce the interest by 10 days.
Okay.
If that takes care of it.
That's fine by me.
Huh?
What is that?
That's
Toby Mac.
probably not.
You want to go on to the next one?
Yes.
Okay, let's do Lanisha. I don't know how to say her last name.
Which,
You mean the case number?
What is the first letter in her last?
L.
L.
Oh, Meteor.
Meteor. Okay.
where is,
All right.
Lanisha.
All right.
Okay, we also had to hire a recovery agent on this one. That forfeiture judge was May 8th. Nisi was entered on June 1st.
no, what case is that?
That,
What's the case number?
Yeah.
M 332-118.
Okay,
Okay,
Lanisha Matuire.
there you go.
Okay,
Okay, Judge, bond forfeiture was May 8th of 23. Nisi was done on June 1st.
oh, let me have to get those, I was looking at that.
May
Say, so you say the bond forfeiture,
May 8th, 23.
May 8,
Nisi was done on June 1st.
Nisi, June 1st,
The
okay.
warrant was not issued until June 19th, so that's 42 days.
That's that, so that'd be a capias. June 19th,
Yes, sir.
June 19th. So, okay,
When was the capias issued? Was the warrant the capias issued the
June
same day?
19th. Well.
apparently it was 18 days later.
Mhm.
What's that?
The Matuire is, 332-118. So.
523.
You said 523? I thought you said 58.
5/8.
5/8.
I'm pulling it. Oh, it wasn't filed till the 23rd, sorry. It's May 8th
Okay.
Okay, May 8th.
and the,
Capias.
You don't, the Nisi, she said the Nisi was on June 1st. And then she said the Capias was June 19th.
click on it.
June 19th.
They don't have it. It just says.
Oh, we can't, there's no
I
document.
just pulled it up on my portal on my phone with the images.
She might have it.
Yeah, we can, that's strange. It
You
should
know
be-
what the capias is?
Yes, sir, until I got it.
That's 6/19. When's the warrant? Same day?
No, KPS. is
June 19th?
Well,
Oh,
is the KPS, is that the Nisi?
No.
No, the Nisi was June
June
1st.
1st, the KPS, the warrant was not issued till June 19th.
Right.
There should be something that says capias. It should list it as capias. Or order for capias, I think is the way it's titled. Oh, here I've got it on wrong. It's the next.
So it was done within 18 days on this one.
Right, but it was 42 days from the date of the forfeiture. The warrant didn't come out for 42 days. Is that 42 days?
I don't know what.
You
what's
thought
on
she's come
6/19.
from May 8th to June 19th, right?
Yes.
That's what you got?
Yes, sir.
Let's see, let's figure 28. I'm showing, I mean, this is in my head, I don't know.
30 and 11.
Uh,
30 and 11, about 41, so in that
Yeah.
range.
42 days, yes, sir.
Yeah, I mean, it depends on how many days they had in this month. of May. Okay,
So that one was 21 days, whatever the days over the, well,
The
We
from
don't-
Nisi to
we-
Capias was 18 days.
The
If
KP.
that's what you was looking for.
Right, it's loading, it's a little slow in here.
Okay,
He's talking about June 1st to June 19th.
It says, KPS bond for.
what's that?
We're running from June 19th.
Okay,
Right.
Keep wanting it from June 19th.
Right,
okay.
correct, on the date of the warrant.
So that's an 18-day interest we're looking at right now.
But when was the Capias entered? Was that the same day? as
June 19th.
June 19th, with this Capias and the warrant were both entered the same day? Or could we ever find the
I think they're
Capias?
one.
It's low.
You don't have.
we don't have an, on Odyssey, she can't see the image, but she
What
can't.
day do they show that they created the event?
Hey, Bradley, you're on.
That's what you're talking about?
tab.
Should be,
I went in
should be.
I'll say.
It's not-
It's in documents.
It's
not-
not- I've seen many that say.
Okay, so we're talking about.
Yeah, that's a tab.
They'll have a
PDF or the Word. So we have,
It
let's
says
call it
one
KPS
June
order.
6/19.
and then judgment in EC.
That's all it says. Yeah.
Caleb,
KPS order.
click on that. So the bailiff's call was also the Capias. Look at the bailiff's call.
Oh, then, yeah, that was,
The bailiff
But
call?
they
On the
normally
bailiff's
do
call.
separate. They normally do
Bailiff's call at the bottom,
separate.
it says
It says
order
Capias.
for Capias, but that,
That's not the actual.
That's not
that's
the
the court
Capias.
ordering.
Right.
it,
Right,
but
that's
that's not
court
getting
order.
over there.
Let's go
getting
back
That's
it.
all.
So judgment issue.
That
So
should
there may
still,
not actually be, we may just have text saying that that warrant was issued June 19th and no document.
So what I go by is the bottom of the judgment NEC, right? It says signed on June 1st,
right,
right? Then you come up here and it was filed in the county clerk's office June 1st. Where you go to the actual warrant, it wasn't issued until May 26th. So, which you can go to warrant return.
4 days before.
No, I'm sorry, June 19th, I'm on the wrong person.
Okay.
Oh,
all right.
yeah.
Sorry.
Got you, didn't I?
Yeah.
You're trying to confuse me,
Yeah.
Judge.
Let's
Throw all these
see.
dates out there.
So yes, it says right here, sheriff's return came to hand on June 19th, 23, is what it says there.
Yeah, that's the order for Capias.
And the NEC was done on June,
Oh, that's the sheriff's. return.
One,
This is
June
the-
1st.
Okay, so this is June 19th.
right,
Yeah, that's what you gave us. So that was the date. And they entered the warrant the same day. I'm guessing they did.
Yeah, I think,
It says
I think on
bond
that
forfeiture.
part, the warrant and the KPS are one and the same.
usually the warrant and when
Okay.
the NEC is done, usually.
The same day, just like the other, one. and did
Usually,
it on the same day.
yes,
Right.
So they did this one 18 days later, like the other one was 20 days later.
yes,
Your Honor, we can run interest from the date
June
of
19th.
June 19th.
Okay.
so that'll give us 18 days on that, correct?
Yeah.
Okay.
Well, I don't know. I didn't do the calculations, but.
Yeah.
Well, if you're going from
June
June 1st to June 19th, trust me. Gwen.
Yeah.
My Keith doesn't have to drive in.
Yeah.
Okay, what else?
Last one is, Aaron Simpson, that's M334126.
Simpson,
Yes, sir.
334126.
Bond forfeiture, April 25th of 23,
Okay, you said bond forfeiture, April
25th.
25th. Okay.
The NEC was signed on, May 26th.
Nisi,
Yes, sir. And the warrant was issued.
May 26th.
I'm showing May 11th on the Nisi.
Hmm.
You said- what you have?
Yeah, Simpson,
Yeah.
Mainland.
May 11th.
May 11th.
Okay, well, the warrant didn't come out till May 26th.
Okay.
So the warrant was May 26th, that's 15 days.
15 days.
Yeah, we can allow 15 days. I mean, so that's 5 days over.
Right.
One, two.
Or you could just alleviate all interest on that one, because, I mean, if we're going, it's
It's $9.21.
$9.21, that's lunch.
Yeah, yeah. I don't know
Mayor,
where I don't know where you've been eating lately.
I'll get a kid's meal, okay? Yeah, it adds up.
Okay,
So,
So-
So run it from May 26th.
Mhm,
Does that sound right?
mhm.
All right, Your Honor, we can run interest on that one from May 26th.
Okay,
I'm happy.
okay.
All right.
Y'all got that?
Anything else?
Yeah, we're done with that. Otherwise, Your Honor, we would ask that the court take judicial notice of its docket as revised with the numerous revisions. And we will, well, and the ones under advisement, I'm trying to think.
So. They're gone. You can't
Yeah.
really look up the question, but.
All right, you can put it back on the docket and then I guess you can look at it and we'll, or y'all can talk.
We can.
You can talk to them and see if y'all can come to an agreement.
Yeah, we'll propose, Your Honor, just what we're doing for Keith, whatever the date,
Date from the warrant issued,
the date from the warrant issue.
But I think,
Okay.
Run it,
do the same for him.
yeah,
Oh.
do the same for Al as well.
Yes.
And,
Oh, I guess. anybody.
well, but I guess, I mean, well,
I feel like we
sure.
have to do it.
Yeah, I mean, we'll do it for everyone.
Should have just went first. We could have been out here a long time ago.
But again.
I'm sorry.
Yeah, but you had all of your
Al's
stuff,
arguing for all
in order.
years.
you had all your stuff together.
Yeah, he wants the whole
Yeah.
enchilada.
All the interest.
Yeah, he's greedy.
Well, it's Al. You've got a license plate that says Prime Pays. I mean.
Prime
yeah,
Pays.
that's what it's-
Oh, wow.
But anyway, Your Honor, yeah, I guess the one, we'll enter, we'll do the recalculations on the ones with Keith Days. And did you make your ruling on Al Reed's or were you taking that one under advisement as
Oh,
well?
I thought you and Al was gonna get together.
Okay, we'll get together on that one.
By agreement.
Yeah.
See if we can do those by agreement. And then the other ones you were taking under advisement were the,
That was the ones with, Bell America, but I think they have the same issues that they have. So I mean, y'all might need to talk to them to see if y'all can come to an agreement on those
okay.
because it's, yeah.
Do them all. The ones that haven't been, are there any that otherwise haven't been addressed? There's a few, the ones that, Your Honor, let me backtrack. First of all, I'd ask that the court take judicial notice of the bond forfeiture docket,
Or would take you just a notice of the bond forfeiture docket.
with the exception of the numerous cases that we've discussed here today. Well, but excluding Keith Days because we will include him on this docket and we will adjust the interest on those particular bonds as discussed before the court. And we will run it by Tamara to make sure that she's in agreement with that. We would ask that the court enter judgment according to the court's docket with the exception of those cases that we
Okay,
pulled out.
judgment shall be entered.
And we may be able to get rid of the rest of them by talking to the bondsman.
Okay,
And if we can, Your Honor, we'll submit those as well.
okay, that's fine.
All right, thank you, Your Honor.
Okay, you
Oh,
welcome.
and also I want the court to take judicial notice of its file too.
The court will also take judicial notice of the court's file.
All right.
And let's do
I will
this
give
here.
you back your book, Your Honor. I will
All right, this will conclude the calling of the court's bond forfeiture hearing on the day's date of March 13, 2024, in County Court Law Number 2, Jefferson County, Texas. Everyone, please have a blessed day. You excuse.
Bonds